Yes, sirs and ma'ams and undecideds. Welcome to the stream. We got our once and only time shirt. You'll never see that again, but good times for all. Welcome to Remedies. Remedies nuts. State Farm Mutual Automobile Insurance Company versus former President Trump. You racist, right-wing conspiracy theorist, Jan 6ing evil person, you. All right. We're dealing with punitive damages that are somehow mitigated by the Constitution of the United States. All right. 2003 case. So, State Farm. What was that? That fucker, what's his name? Jake? From State Farm? Chat? Jake? Right? That fucker? Jake? Yep. No. Jake's gonna go down, maybe, hopefully. Don't know. In 1981, so I don't think Jake was even born yet, Curtis Campbell tried to pass 6 vans on a 2-lane highway in Utah. Well, that was a fucking mistake. He caused an accident that killed one driver, whose name was Ostapol. Probably a Russian communist spy. Don't know. Just guessing. Ostapol sounds Russian, sounds communist, sounds spy. Oh, and he also permanently disabled another person named Slusher, which sounds like a fake name. Anyways, Campbell's liability insurance was with State Farm, and they covered $25,000 per person. But State Farm refused offers to settle over policy limits. The jury found that Campbell was 100% liable, and it was at fault, and rendered verdicts totaling nearly $186,000, $25,000, $186,000. A little bit, right? State Farm refused to pay the part of the judgment that exceeded the policy limit of $25,000, and refused to post a supersedious bond to delay the collection of judgment while Campbell appealed. Campbell then hired his own lawyers. Well, good fucking idea, Campbell. Because if you have a fucking law firm or a company, okay, if you're working for a company or you have an insurance company that represents you, don't use them as your lawyers. The only thing they're going to do is try to look around and find the nearest bus and throw your ass under that bus as soon as possible. Don't do it. I mean, people tell me, don't do it. Don't do it. All right. State Farm refused to pay part of the judgment. Campbell then hired his own lawyers. Good idea, asshole. Who negotiated a settlement. Slusher and Ostapol's estate, because Ostapol died, agreed not to collect from Campbell. Campbell agreed to sue State Farm. So now Campbell's suing State Farm. Yep. And oh, okay. Oh, and when he decided to sue State Farm, Slusher and Ostapol's lawyers agreed to represent him. So now the people that were suing him just flipped. And now all the lawyers are on his side suing State Farm. Right? And he also agreed, stop suing me, sue State Farm. And guess what? I'll give you all 90% of what you recover from State Farm. So we're going to flip the fucking script and just don't sue me, please. And you can sue the other person and you get 90%. So they did it. The Utah Supreme Court denied Campbell's appeal in the original tort suits, Slusher versus Ostapol, ex rel. Ostapol, a 1989 Utah Supreme Court decision, and State Farm belatedly paid the entire judgment. There you go. The Campbells then sued State Farm, alleging bad faith refusal to settle, fraud, and intentional infliction of emotional distress. The latter of those charges is a bit odd, right? The evidence showed that State Farm set corporate financial goals that required capping the amounts it would pay on claims, without regard to the number of claims or the claim's merits. That's a problem. To meet these caps, State Farm often refused to pay claims on behalf of unsophisticated insured people who were thought unlikely to complain effectively. So basically, if you're Jack Smo, Joe Schmo on the street, State Farm's like, fuck you, you don't know what you're talking about. We're not paying you. Yep. State Farm put false documents into the claim files and removed the real documents that suggested actual liability and destroyed claims handling manuals that might have revealed their scheme. Problem? Yeah, problem. Former State Farm employees testified to the scheme, and one former employee provided a copy of the 1979 manual in which the scheme had originated. Justice Kennedy delivered the opinion of this court. 1. The jury awarded Campbell $2.6 million in compensatory damages. State Farm did that. Jake, if you're watching, Jake, give me the fucking Aflac duck over Jake. I trust that fucking duck that's voiced by Gilbert Godfrey, who read 50 Shades of Grey to a great extent, I might add, over that fucking duck. F you, Jake. Anyways, no liberty, no limu, no emu, no nothing. Bad chat. Bad chat. You're in timeout. No. No emu. Okay. The jury awarded the Campbells $2.6 million in compensatory damages, no emu, and $145 million in punitive damages, which the trial court reduced to $1 million and $25 million, respectively. Both parties appealed. The Utah Supreme Court sought to apply these guidelines we identified in the Utah Supreme Court BMW Incorporated versus Gore, not Al Gore, a different Gore, I imagine, 1996 case, and it reinstated the $145 million punitive damages award. These guideposts were the degree of reprehensibility of the defendant's conduct and the ratio between the punitive damages award and the harm that would likely result from the defendant's conduct, as well as the harm that actually has occurred as a result of this misconduct, the civil or criminal penalties that could be imposed for comparable misconduct. The Utah court concluded that State Farm's conduct was reprehensible. No shit. They were deleting documents and burning documents and throwing manuals away and putting fake documents into the fucking folder. Like, that's fucking reprehensible. Duh. The Utah court concluded that State Farm's conduct was reprehensible. We already said that. They said it again. It's because it's really reprehensible. The court also relied upon State Farm's massive wealth. Massive wealth. And on testimony indicating that State Farm's actions, because of their clandestine nature, clandestine means like covert, like Al-Qaeda, Bin Laden, clandestine. State Farm, apparently, also clandestine. Yep. I lost my place. Clandestine. Yeah, nature. Were to be punished at most in 1 out of every 50,000 cases as a matter of state statistical probability. Utah Supreme Court decision 2021. And concluded that the ratio between punitive and compensatory damages was not unwarranted, meaning like, yeah, 1 million punitive, 1 million compensatory, 25 million punitive, yeah. Because punitive damages are to punish you so you don't do it again. Bad baby. Punitive damages. Don't do it again. That's the whole point. Finally, the court noted that punitive damage award was not excessive when compared to various civil and criminal penalties that State Farm could have faced, including $10,000 for each act of fraud. And there were a great many acts of fraud in this case. And also the suspension of its license to conduct business in Utah. So they could have said, State Farm, get out of Utah. Go somewhere else. No longer in Utah. They could have done that. They didn't do that because that would cost, like 1 out of every 5 insured people have State Farm probably. And so there's a bunch of millions of people in Utah. And if the court was like, no, you're gone, never more in Utah, State Farm stands to lose a lot more money than they would if they just tack him for $25 million off the top, which sounds crazy, but if you do the math, it works out, right? State Farm is not there in Utah. Like a good Mormon neighbor, State Farm ain't there. Sorry. Anyways, 2. While states possess discretion over imposition of punitive damages, it is well established that there are procedural and substantive constitutional limitations on these awards. The Due Process Clause prohibits the imposition of grossly excessive or arbitrary punishments for a tortfeasor. The reason is that, quote, elementary notions of fairness enshrined in our constitutional jurisprudence dictate that a person receive fair notice not only of the conduct that will be subject to punishment, but also of the severity of the penalty that a state may impose. Right? That's from the B&W case. To the extent that an award is grossly excessive, it furthers no legitimate purpose and constitutes an arbitrary deprivation of property. Okay, so basically what they're saying here is that, okay, like, we hate you, State Farm, so we're going to go in hard on you and just give us all the money, F you, F you, F you. So State Farm should have, or any company should have some ability to expect that kind of damage award in a case. Since State Farm had not been put through the ringer before, the court saying here that State Farm was due some more notice than just like all of a sudden, since you've been frauding stuff, we don't like you, State Farm. So somehow the court's coming out on State Farm's side saying, we're not going to do all the hard things to you right now. Fix yourself, right? Yeah. So although these awards serve the same purpose as criminal penalties, defendants who are subject to punitive damages in civil cases have not been accorded the protections applicable in criminal proceedings. So what they mean by this is that, okay, so in a criminal proceeding, the standard of proof is beyond a reasonable doubt, which means like really high, like 95% plus, right? In a civil proceeding, which this was, it's preponderance of the evidence, which means 50% plus a feather, right? So State Farm is arguing you're giving us criminal-like penalties, but you're doing it with a much less strict burden of proof, meaning that they can give us 51 and a feather of proof and we're fucked. Whereas if these were criminal penalties, it would be beyond a reasonable doubt. And you haven't given us the jury the instructions to do beyond a reasonable doubt. And so we are suffering our due process violations as a result of that. Let's see what the court says. I don't think it's going to go well for them, but that's a good argument. Anyways, or it's an argument at least. This increases our concerns over the imprecise manner in which punitive damage systems are administered. That's a good point. We have admonished that punitive damages pose an acute, I'm not German, an acute danger of arbitrary deprivation of property, meaning money and stuff for the people who are being screwed over. Jury instructions typically leave the jury with wide discretion in choosing amounts, and the presentation of evidence of a defendant's net worth creates the potential that juries will use the verdict to express biases against big businesses, particularly those without strong local presences. Okay, right? So, so we have Toyota. Toyota does not own and operate a Toyota plant in Utah, right? Toyota, rich company, right? So when you get past, so there's 2 phases in the trial. There's the liability phase, which says, was the company wrong? Jury says, yes, company was wrong. Then you go to the punitive damages and damages award phase, when the jury says, okay, they were wrong. So now the jury gets to get all the financials of the corporation, say, how rich are they? And based on that whole question of how rich are they, they say, well, how much is a dollar amount that's going to make them hurt enough they're not going to do it again? So if Toyota's worth $25 billion, the jury has to ask themselves, how much of an award is going to hurt Toyota, right, to the point where they're not going to do this fuckery again, right? And so it gets very high amount. And the whole thing about a local presence is somebody might think, oh, wow, well, bro, there's like a Toyota plant like down the road. And like my cousin Eddie works at the Toyota plant. So like, I don't want to like hit Toyota so big, right? So that they have to close the plant down because then cousin Eddie loses his job. But the court is saying here, well, there is no Toyota plant or factory or anything Toyota related to except probably dealerships in Utah. So nobody's going to want to not hit Toyota hard in Utah because they're worried about the local presence and the local effects. So somebody in Utah could be like, screw Toyota, man. Screw Buffalo, West Virginia, screw Toyota, right? And then what would happen, because there's no local presence, right? So because there is no local presence and because no one stands to lose from it, the jury will probably be harder on Toyota because they have big pockets. And so they're going to do more damage to Toyota than it's probably just that they would do, right? So, okay. Point 3. Hope that makes sense. Chat, does that make sense? What I'm talking about? It's not what I'm talking about, chat. Also, hey, just shout out other person out there who's not the mod, who's listening. Hi, I appreciate you, whoever you are, wherever you are. Like and subscribe if you would. If not, enjoy the show. Props. Appreciate you. Send a chat if you want to send a chat. It's so blessed to have you here. You are our one and only fan, and that's fucking enough for me, man. Good for you. Mod, send a thank you to whoever that person is. Random Chatter 001. You are my favorite. Mod, do it. Thank you. All right. Point 3. Or Roman numeral 3. The tray. My finger's not working right. The tray. Get down, you. Chat. Viewer. Oh, yeah, viewer. Oh, that says viewers. You're right. Welcome, viewer. The most important indicum. That's a good word. It means like it's indicative. It indicates a thing. The Supreme Court thinks they're smart. Indicum. The most important indicum is, whatever. Of reasonableness of a punitive damage award is the degree of the reprehensibility of the defendant's conduct, right? So the amount we're going to give you in punitive damages, right, depends upon how fucked up the thing was. I'm sorry if the viewer has children. I hope you don't. I don't think you do. It's late. So the amount of damages relates to how fucked up the thing was that the person did, that Toyota did, or State Farm did, right? So like, it was a little bit bad. Nah. But like, it was a lot bad. More pain to you. Yes, sir. May I have another? You can't get the pudding if you don't eat your meat, right? All right. We have instructed courts to determine the reprehensibility of a defendant's conduct, considering whether the harm caused was physical as opposed to economic, the tortious conduct evinced, meaning evidence, they think they're smart, an indifference to or reckless disregard for the health or safety of others, the target of the conduct had a financial vulnerability, the conduct involves repeated actions that was or if it was an isolated incident, and if the harm was the result of intentional malice, trickery, or deceit, or was it mere accident, right? So basically, like, okay, if you're trying to take advantage of a disadvantaged community, if you're trying to do fuckery on people to make money at their expense, if you decide that you're going to hurt a person or group of people specifically, right? Those are reasons we want to give you punitive damages. Punitive. The root word is the same as punish. Damages that punish you. That's the whole point. And so these are the ways we tell how fucked up you are as to if we're going to give you those damages or not, right? So that's where we're at. Applying all these factors of fuckery to the instant case meaning this case. They say instant case at bar means this case, right? We must acknowledge that State Farm's handling of the claims against Campbell's merit no praise. It's not good for State Farm. The trial court found that State Farm's employees altered company records to make Campbell appear less culpable. State Farm disregarded the near certain probability that by taking the case to trial, a judgment in excess of policy limits would be awarded. State Farm amplified the harm by first assuring the Campbells that their assets would be safe from any verdict and later telling them post-judgment to fuck off or to put a for sale and to put a for sale sign on their house. Jake, bad Jake. While we do not suggest there was an error in awarding the punitive damages based upon State Farm's conduct towards the Campbells, a more modest punitive establishment for this reprehensible conduct could have been satisfied if the State Farm's legitimate, a more modest punitive settlement could have satisfied State Farm's obligations. So basically, like State Farm, if you weren't doing so much fuckery, you could have settled for a less verdict and saved the Campbells time and money and you time and money. And now we're letting the Campbells off the hook because you fuck with them and you're trying to use them as your patsy. So bad, Jake. This case instead was used as a platform to expose and punish the perceived deficiencies and malfeasances of State Farm's operations throughout the whole country. So, okay. Now the court's like, yeah, State Farm's done fucked around, but we can only, this case is a Utah case, so we can only really deal with that in Utah. So now the Supreme Court's going to be like, suck some damages back. That's what I'm feeling. I mean, I'm feeling it. My spidey senses are tingling that they're going to take it back from State Farm and give them less damages now. So we'll see. A state cannot punish a defendant for conduct that may have been lawful where it occurred, nor, as a general rule, does a state have legitimate concerns in imposing punitive damage to punish a defendant for unlawful acts committed outside of the state's jurisdiction. Okay, so basically we're going here, right? It's like the jury is pissed at State Farm. The jury should be pissed at State Farm. State Farm is not there. State Farm is screwing people over in every county in every state in America. However, the scope of this one case is limited to the Campbells in Utah. And evidence came out in this case that State Farm is screwing people the whole country over. And the jury got a burr up their butt, right? Jake, sit down and shut up. But the jury got a burr up its butt and was like, no, State Farm, we're going to punish you everywhere. And the Supreme Court says, well, yeah, we understand why you would want to do that. But you can't do it in this case because this case is only about the Campbells and only in Utah. So the $25 million you're trying to hit State Farm with, even though we agree this fuckery, we agree they suck, you can't do it in this case, jury. So this happens. Juries get outraged. They see because juries get to see all the dirty laundry and the evidence that was laid out. They get to see the fake documents, the burning of documents, the putting fake documents in, the deleting real documents. And the jury's pissed because like, how dare they? And the court's like, yeah, how dare they? But because the way the law works, you can only how dare they in Utah, not everywhere. And so that's what they're saying is like the jury is trying to punish State Farm's nationwide operation, right? I mean, apparently they are. This was 03, so maybe they fixed their ways. Doubt it. But 06. So maybe they fixed it. I don't know. I'm a Geico guy. Sorry. Because of military discounts and stuff. Anyways, so the court saying, like, you can't punish State Farm nationally for what's in Utah. The scope of this case is Utah. You have to restrict the damages to Utah standards, okay? All right. And then the court says, for a fundamental reason, however, the Utah courts erred in relying upon this nationwide evidence and other evidence. The courts awarded punitive damages to punish and deter conduct that bore no relation to the Campbell's harm, like I was just saying. They got a bunch of evidence from the whole nation. They screwed everybody over, right? But the harm we're addressing in this court case is the Campbell's harm. The jury got a bunch of information from all over the country, was rightfully super pissed off, and dropped the hammer on State Farm. But it's not right for this case, for the Campbell's recovery. That's what they're saying. All right. A defendant's dissimilar acts, independent from the acts upon which the liability was premised, may not serve as the basis for punitive damage. So if you've got Mary Jane in State A and Billy Bob in State B, and you're fucking over Mary Jane, and Billy Bob, you're fucking him over too, right? The jury can't say, hey, you're fucking over Mary Jane and Billy Bob. We're going to get you for both of them. Nope. Because Billy Bob is in State B, you only sue. Billy Bob can only get recompense in State B. Mary Jane can't help Billy Bob get recompense in State A. Does that make sense? You can't. But the jury saw the incredible amount of corruption and was like, burn them all of them, every state, all the money, all the home, right now, do it. And the court's like, we understand why you did that, but you can't do that, right? All right. So it says a defendant should be punished for the conduct that harmed the plaintiff, not for being an unsavory individual or an unsavory business. Like I said, like people like State Farm is a piece of crap, so burn State Farm to the ground. The court's like, yeah, we know they're a piece of crap, but you can't burn them to the ground just for being a piece of crap. You need more than that in this given state, right? Due process does not permit courts in the calculation of punitive damages to adjudicate the merits of other parties like Billy Bob and State B, right? Hypothetical claims against the defendant under the guise of reprehensibility analysis, being like, you're so bad and so filthy and so dirty, we're going to murder you everywhere. No, that doesn't work under the analysis, right? Punishment on these bases creates the possibility of multiple punitive damage awards for the same conduct for the same usual case. Non-parties are not bound by the judgment some other plaintiff by another plaintiff that obtained. So, like, again, Mary Jane and Billy Bob, right? Like, because Mary Jane has a good case, made a good case, presented it, and got awarded damages, right? Unfortunately, even though Billy Bob was screwed over the same way by the same policies in a different state, right? The way the American legal system works is that Billy Bob has to bring his own case and bring his own facts and have his own jury give him his own damages. The court system in America doesn't work that Mary Jane did X, Y, and Z and got these damages, so we're just going to give him to Billy Bob too because it's similar enough. No. Different state laws, different state sovereignty, different recovery options. So that's why that happens. I mean, it sounds kind of crazy because you're like, well, it's the same fucking thing, same fucking policies, but like the American legal system, Billy Bob's got to bring his. You can't sue for somebody else. So like, okay, so like if I'm walking down the street, right, and I see Chat there, I see Dr. Portia G. Smith, right, I see there's Mary Jane walking her poodle on the street. I see Dr. Portia G. Smith run up and kick the poodle in the head. And Mary Jane's like, oh my God, you kicked the poodle in the head. Oh my God, I'm emotionally distraught. Oh. Right? I can't go to the court and sue Dr. Portia G. Smith for kicking Mary Jane's poodle in the head. Mary Jane has to go to the court and sue Dr. Portia G. Smith for kicking the poodle in the head. I can't sue on behalf of somebody else. And so that's just the way it goes. And so what they're saying is that because if Mary Jane has wrongs done to her in Utah and Billy Bob has wrongs done to him in Missouri, right, the fact that Mary Jane wins her case in Utah does not give evidence to Billy Bob that he gets the same reward in Missouri, right? Same thing as like the third party suit with the poodle and the kicking and the stuff and the Porsche stuff. Yeah. All right. All right. The same reasons lead us to conclude that the Utah Supreme Court's decision cannot be justified on the grounds that State Farm was a recidivist. Recidivist meaning they did this shit before. We told them, stop it. They did it again. So a little bit of a different standard between the whole, like, you're really, really bad. You're a really bad dude. But this is, you're a really bad dude, and we told you to knock it off, and you did it again. So the Supreme Court says, even though they're bad, and you told them stop it, and they did it again, that still doesn't justify Billy Bob recovering in Missouri, apparently. Courts must ensure the conduct in question replicates the exact prior transgressions. And what they mean by that is not only the conduct, but the party that was harmed, which makes it impossible because guess what? When Mary Jane gets fucked over by State Farm, guess who she's not insuring herself with? State Farm. So the likelihood that Mary Jane would reinsure herself with State Farm and they'd fuck her over the same way again is very, very unlikely if Mary Jane's a thinking person, which she seems like she would be. And so this is kind of the way the Supreme Court's giving it out to State Farm because they want the same harm to the same person in the same way over again to allow these kinds of damages. If we just think about it rationally, that's not going to happen, but that's what they want, right? Although evidence of other acts need not be identical to have relevance, they're saying it doesn't have to be identical, but they really do mean identical. Anyways, to be relevant to the calculation of punitive damage in Utah, the court erred here because evidence pertaining to claims that have nothing to do with a third-party lawsuit, like I just said, third-party lawsuits, right, were introduced at length. So basically, like all the bullshit that happened to Billy Bob in Missouri was introduced just to show what a piece of shit State Farm is, right? And they ran with it. The jury ran with it, and that was it, right? So, last part here, okay? Turning to the second BMW. BMW was the landmark case that we're talking about, right? We have been reluctant to identify concrete constitutional limits to the ratio between potential harm to the plaintiff and punitive damages award and putting a cap on what it cannot exceed. Our jurisprudence and the principles it has now established demonstrate, however, that in practice, few awards exceeding a single-digit ratio between punitive and compensatory damages to a significant degree will satisfy. Okay, basically like 1-to-1, single-digit ratio. 9-to-1, single-digit ratio. 10-to-1, double-digit ratio. We're worried now, apparently, says the Supreme Court, right? So that's what I mean by single-digit ratio, right? In Pacific Mutual Life Insurance Company versus Halsip, 91 decision, in upholding a punitive damage award, we concluded that an award of more than 4 times the amount of compensatory damages, the damages that are to recover to you the state you were, and not the punishment damages of punitive award, right? We concluded that an award of more than 4 times the amount of compensatory damage might be close to the line of being constitutionally improper. The court further referenced a long legislative history dating back to over 700 years and going forward to today, providing the sanctions for double, treble, or quadruple damages to deter and punish. While these ratios are not binding, they are instructive. They demonstrate what should be obvious. Single-digit multipliers are more likely to comport with due process while still achieving the state's goals of deterrence rehabilitation. Awards that have ratios of 145-1, less cool. So this is the court thing. It's like, okay, so we're saying like, okay, so again, we went through this last time. We'll go through it again. Compensatory damages are damages that try to make you whole. You got hit while you're riding your bike by a car. So now you have broken leg, broken pelvis, have to go to the hospital, have doctor's bills. You also have lost wages because when you're in the hospital, you can't go to work, right? So compensatory damages are those damages which pay for your medical bills all the way up and pay for your lost wages from the moment you were hurt up till the time you're all the way better and go back to work. And if you are disabled enough because of the accident, you can never go back to work, then compensatory damages will pay you for your lost wages from the time of the accident until using an actuary, like if you're a man, it's like 68 in America, a woman 74, right? The expected life expectancy you have, right? So they'll pay you out a prorated wages amount for however old you are when you got hit until the time you would probably die, right? That's compensatory damages, compensating you to put you back in the position you would have been in prior to the accident, right? So punitive damages are to punish the asshole or the asshole company who did this to you or who fucked you over. In the case of Jake and State Farm, right? To punish them so they don't fuck other people over. Like bad. Don't do it. Screw them over, right? So what the Supreme Court is saying here is that punitive damages can get big because we want to make State Farm is a big company. It's got billions of dollars. So if we were like, well, $100,000 State Farm, pay it up. That's like they can find that much money in their couch cushions, right? So you have to make it bigger and make it hurt for them to actually care about it, right? So the freaking jury gets to look at their financials, see how much the whole company is worth. And then based upon that amount of net worth, gets to establish what is punishment enough, what dollar amount is enough punishment to make them not screw other people over in that same way, right? And so the Supreme Court here's here saying that, okay, usually single digit multipliers, 2 times, 3 times, 4 times, 5 times, 6 times the compensatory damages, right, is usually enough. But sometimes maybe the conduct is so think about it this way. Okay. The compensatory damages, I get hit by a guy and I break my leg or my leg comes off. I don't have a leg anymore. I got a prosthesis now, right? There goes my track career. Not that I had one, but there goes my ability to you live a normal life. So I'm going to get medical damages for all the cost of my treatment from now till I die. I'm going to get lost earnings to some extent based upon what job I can have now, right? So say the jury gives me from now, I'm 37. Say it gives me from now till I die 72. That's 40 plus years. I don't math, 44 years, right? So 44 years of lost earnings I could have had, right? And gives that to me, right? So that's probably, 250K, even if I'm a Walmart worker, probably something like that, right? So give me 250K plus medical bills of 100,000, so $350,000, let's just say, in compensatory damages to make me whole as I was before the accident, right? Before I got hit. And so the Supreme Court here is saying, well, punitive damages to punish people for doing bad things, right? 1 times 350K, 2 times, 3 times, 4 times, 5 times, 6 times, 7 times, 8 times, 9 times, 9 times 350K, which would be like 22.7 mil. That's fine. We're with that. But if you go over that single digit multiplier into double digit multipliers, we're shady on that because that might be too much. So, right. So here we have 145 to 1 is what they're talking about. So if I were to get 350K, right, times, I don't even know, times 145, chat, can you do that? I don't even know. So 350,000 times 145 was the ratio they were trying to impose on State Farm because of the heinous of their action. And they're saying, the Supreme Court saying, that seems like it's a bit too much for what we're trying to accomplish. That's like 700 million, at least. 700, 809, that's close to $1 billion. 875 million-ish, I think. 350K times 145. Right? They're saying that seems like a bit much for us. So we're going to draw it back down and to try to use some other method. Basically, like anything that's between 1 and 9 times, we're okay with. But you get into the double digits or the triple digit multipliers, we're not doing that. And that's what the court concludes, right? So it says that the argument that State Farm will be punished in only a rare case, coupled with reference to its assets, which of course are what other insured parties in Utah and other State Farm and other states must rely upon. Again, the jury gets to view all the financials. So like State Farm, multi-billion-dollar company, screw them over. They have all this money. Well, we have to apportion their assets. Okay, so say the jury awards the plaintiff 3 times as much money as all the State Farm customers pay all year in Utah. Well, that's kind of screwed up because the Utah claim in Utah courts, and we're going to give them more than anybody in Utah pays in ever, right? So that's the issue, right? So the Supreme Court decides that the amount that was awarded had very little to do with the actual harm that was sustained by the Campbells and more to do with the wealth of the defendant, like I was saying, the amount of money in the pockets that State Farm has, right? And because the award was based only on how rich the whole company is, they can't justify that award to the Utah defendants or plaintiffs, the Campbells. The decision is reversed and remanded for reconsideration with basically use less than a 145-1 ratio. If you go between 1 and 9, we're good. Single digit ratio. So in my example, 350K, you can multiply by 9. So 2.7 mil, we're cool with, but not 270 mil. That's what the court remands back to the trial court to consider. The trial court reversed as well and held it. I think they got they ended up getting like $3 million. The Campbells got like $3 million all told after lawyers' fees and everything, which, I mean, $3 million richer than they were before. All right, folks. I appreciate y'all being here with me. It was great to do some more deep diving to actual legal. I think I'll do more. I think I'll do less reading. I mean, I'll keep reading cases, but do more analysis. Likes in the chat. Ones if we like the analysis as opposed to just the reading. Thumbs up. Middle fingers up. Whatever. We like the analysis. We like just reading. What do we like? I don't know. Many people tell me that everybody likes other things. I don't know. It's a very big, beautiful chat. I don't know. Anyways, tip your bartenders, tip your hostesses. Have a great night. God bless you all. Hoochie coochie. God bless America. Happy February 20th. We'll see y'all tomorrow for conflicts of law and more remedies. Take care. Bye-bye.